This video presents an analysis of the procedure and method of local examination, based on Article 5, covering the normative, philosophical, sociological, and juridical review. Article 5 covers 4 key points: basis for stipulation, commissioner-judge, open hearing, and case costs. This summarizes the material in Article 5 for local examination implementation. The 4 points covered in Article 5 ensure a transparent and responsible process for local examination, covering the basis of stipulation, role of the commissioner-judge, open hearing requirement, and case cost procedures. The normative and philosophical basis for the stipulation includes the judge's authority, judge's initiative, and legalization under normative rationality. Philosophical foundations emphasize the judge's proactivity, due process, and participation to ensure justice and procedural fairness. Sociologically, the stipulation prevents non-executable decisions due to inaccurate dispute objects. Juridically, it is based on Article 153 HIR, Article 180 RBG, and SEMA No. 7 2001, acting as a professional filter for judges regarding procedural actions. The Commissioner-Judge's sociological foundation responds to limited judicial resources and high case burden, enabling local examinations in remote areas without disrupting the main hearing schedule. Juridically, this is affirmed by Article 153 HIR-JO, Article 211 RV, where examination results are recorded as official evidence. The role of the Commissioner-Judge is a practical solution to resource limitations, allowing remote local examinations. The juridical basis ensures the findings are documented officially, serving as valid information for the deciding judge. The open hearing's normative rationality is rooted in the valid requirement under Article 13 of the Judicial Power Law and the Formal Administration Requirement. Philosophically, it ensures transparency, accountability, and public justice, so that justice is seen to be done. Sociologically, open hearings address public demands for transparency in costs and procedures, preventing biased perception. Juridically, it is regulated by Article 13 of the Judicial Power Law and Article 59-60 UU 7 1989, analogized with PERMA 2 2016 and PERMA 8 2017 for important stipulations. The normative rationality of examination costs involves the real cost, PNBP regime, and chairman's authority. The philosophical basis includes the principle of responsibility, distributive justice, and protection of the poor, ensuring fairness and preventing misuse of state budget. Sociologically, the cost provision prevents conflicts due to lack of funds or unclear transport. The chairman's official estimate prevents unofficial levies. Juridically, it aligns with Article 214 RV, PP, PNBP, MA, and PERMA No. 1 2014, solidifying the legality of advance fee payment to the applicant. The synthesis of Article 5's juridical basis summarizes the procedural aspects, including the initiative, formal legality, field implementation, openness principle, and funding, each linked to key legal instruments and explanations. This video will analyze Article 6 regarding the notification of on-site examination, PS, focusing on the normative, philosophical, sociological, and juridical rationale within the framework of procedural law. Article 6 outlines 3 key provisions. First, notification to the parties via hearing, e-court, or registered mail for transparency. Second, local officials must be notified at least 3 working days before execution. Third, delegation mechanism, where the receiving court fully coordinates the notification. We begin with Part 1, notification to the parties. Part 2 covers the notification to local officials. This includes regional coordination to optimize the synchronization of physical boundaries and witness support. It requires cooperation through notification at least 3 working days prior. Finally, it ensures public order by maintaining security and harmony in the public space. The normative rationale is based on fundamental rights and certainty. Notification is essential for parties to know and attend the examination stages. The use of e-court, hearings, and registered mail reinforces the legal certainty principle and minimizes disputes over the validity of crucial summons. The philosophical basis rests on due process of law, demanding fair notice and a fair hearing. Accountability is manifested by allowing public audit and supervision of the justice process through official recording. Technology adaptation, such as e-court, modernizes the process without sacrificing the substance of legal rights. The sociological and juridical context involves a dualistic reality, accommodating the e-court digital ecosystem while protecting conventional users. Juridical precedent aligns with Article 9 of PERMA No. 8/2017 regarding summons via various valid communication media. Public trust is maintained by avoiding the perception of a "sudden hearing" that often triggers a no-confidence motion. Part 2 focuses on notification to local officials, ensuring accuracy and validity in the field. The rationale and philosophy behind this notification are regional coordination and public order. PS enters the administrative area of the village/subdistrict. Notifying local authorities 3 days in advance aims to prevent security disturbances and ensure the court's presence in the public space runs smoothly. The sociological foundation addresses the accuracy of the dispute object. Many non-executable decisions result from discrepancies in field data. Local officials hold crucial records for land control, vital for PS accuracy. Social acceptance is also crucial, as a judge's unannounced presence often sparks suspicion. The juridical basis highlights institutional synergy. Referring to PERMA No. 1/2014, out-of-court hearings require coordination with local government agencies for smooth execution. The consistency of the 3-working-day deadline is a standard in procedural law to ensure adequate preparation rights. Part 3 covers the delegation mechanism. Territorial competence ensures the receiving court understands local conditions. Technical efficiency reflects the philosophical division of function between judicial assessment and field execution. Juridical legitimation, per Article 180 RBG, transfers PS execution authority functionally to the court where the object is located. Welcome to this comprehensive analysis of Article 7, focusing on the delegation of on-site examinations and security management from a perspective of legal rationality, presented by Sisep Mustafa. Article 7 mandates that objects outside the legal jurisdiction be examined through delegation to the local court. The court must coordinate with local police for security. If police are unavailable, the court can request assistance from the TNI or SATPOL PP. Judges have the authority to postpone proceedings if security conditions are unfavorable. Delegation of objects outside the territory is based on normative rationality, ensuring relative competence and preventing judges from exceeding their boundaries, as per Article 180 RBG. Philosophically, the principle of proximity to facts suggests the nearest judicial organ conduct observations for accurate environmental understanding. Sociologically, delegation prevents non-executable decisions. Local court involvement, with support from local officials, increases the chance of obtaining accurate data. Juridically, on-site examination is part of the proof process and must respect the court's relative competence, based on a systematic interpretation of Article 153 HIR-JO. Article 180 RBG. Mandatory police coordination aligns with the due process of law principle. Security is a substantive prerequisite for a fair trial. Normative rationality places the police as the main actor in protecting judges and litigants, in line with PERMA No. 5 of 2020 on trial security. Sociologically, on-site examination often occurs in areas with latent tension. Coordination with the police mitigates potential horizontal conflict and intimidation of witnesses. Juridically, Article 12, Paragraph 2 of PERMA 5/2020 mandates the head of the court to coordinate with security apparatus to guarantee safety outside the court building. Alternative security assistance is based on the normative rationality that the phrase and/or TNI in PERMA 5/2020 allows for proportional security collaboration if the police are overwhelmed. The philosophical basis is the protective function of the state, which requires mobilizing all resources to guarantee the safety of judicial apparatus and justice seekers. The TNI's involvement, mandated by Article 10, Paragraph 6 of PERMA 5/2020, provides a deterrent effect against mass violence in high-risk areas. SATPOL PP's sociological legitimacy as a public order keeper is backed by the regional examination law and security apparatus cooperation, as stipulated in Article 12 of PERMA 5/2020. The authority to postpone on-site examination is based on normative rationality. The judge, as dominus litis, has an anticipatory obligation for safety in non-conducive locations. The philosophical basis is the prudence principle, ensuring the judiciary does not trigger conflict, prioritizing social stability for the pursuit of material truth. The balance of risk and procedure involves analyzing the field, personnel briefing, and risk validation. Juridically, Article 9 of Law 48/2009 guarantees protection against abuse of authority. Postponement is the judge's right to ensure a, quote, fair trial amidst threats of field intimidation. The systemic integration of Article 7 focuses on delegation legitimation to respect territorial jurisdiction and bureaucratic efficiency. This must be complemented by security synergy to ensure physical protection as a prerequisite for material justice. Welcome to the video on the analysis of Article 8, implementation of on-site electronic examination within the framework of utilizing modern justice technology. This video will summarize the regulation focusing on the operational framework and stakeholder participation in electronic on-site examination, or PS electronic. Key provisions of Article 8 mandate the use of real-time teleconferencing and drones for electronic PS to visualize the field. Parties are granted full virtual access, including the right to submit objections, which must be recorded in the official minutes. The rationale for this technological adaptation aligns with the principle of fast, simple, and low-cost justice. It ensures the constitutional right to a fair trial and extends the courtroom to the dispute location, solving physical presence barriers in difficult areas. Procedural rights are guaranteed through three key aspects. Virtual presence is legally recognized, objections are systematically recorded to ensure accountability, and transparency is maintained by eliminating participation barriers due to distance or security concerns. The philosophical basis is justice, anchored by due process, intellectual presence, and proportionality. Technology reinforces judicial access to material facts through transparent, real-time visualization, balancing state resource efficiency with evidence quality. The use of drones offers a comprehensive aerial perspective, philosophically expanding the judge's observation radius beyond ground-level human sight. This supports the search for material truth, providing a more precise spatial view of the disputed object. In the social and security dimension, drones mitigate conflict by reducing the risk of physical friction and violence at land dispute sites. They also ensure the safety of judges and parties from field intimidation and respond to the growing digital culture of virtual interaction. Social literacy and acceptance of electronic PS is supported by improved technology literacy and network availability. The growing acceptance of electronic evidence and digital forensics makes drone usage a logical continuation, not an extreme leap, in judicial practice. Sectoral legal foundations include Article 28D, Paragraph 1 of the 1945 Constitution, supporting regulations like PERMA No. 1 Year 2019 and PERMEN Cominfo No. 7 2016, 3, which ensure legal certainty and fair treatment. The trend of judicial digitalization shows an exponential growth curve in the adoption of electronic procedures in the national law enforcement system, moving from pre-pandemic to the current era of digital transformation.